All right, can you hear me?
Yes, but I apologize. I cannot see. The only people I see are the judges.
If you ping on the clock and then make that your screen and then go back and try again, will it populate all of us?
Oh, I apologize. The only people I see are canceled out. If you two can see, then we'll proceed. We're here in our case 1 CACV 19-0556, Bridges versus Nation Star. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for a rebuttal, but you'll have to keep track of time yourself. We have a clock at the bottom of the screen, so you can see how you're doing. We're recording the argument both in audio and video. When it's your turn, please identify yourself and your client so that when we go back to watch the video again, we'll be able to keep everybody straight. In a couple of days, the argument will be on YouTube. We've read the briefs and conference of case and looked at the record, so we're familiar with the case. So when you begin your argument, please just start out with what you'd like for us to know. Counsel, you may begin.
Thank you. May I please report? Good morning. My name is Justin Balser, and I represent Nation Star Mortgage. This case presents a unique opportunity for this court. There's been a number of matters at the trial court level involving the statute of limitations and the impact on home servicers and lenders who foreclose, where there have been intervening bankruptcy matters or loss mitigation, either required by federal regulations or required by lender or servicer policies as a customer service opportunity to allow homeowners to maintain home ownership despite not paying their debts as a way to avoid foreclosure when the borrowers have been in default on their mortgages.
Counsel, from my understanding of the record, the acceleration clauses weren't invoked when the foreclosure occurred.
Yes, that's correct. And the position we take is that the note and the deed of trust, the note at paragraph, I believe it's 8C, the deed of trust at paragraph 22, both in the record, have what's called optional acceleration provisions within them. They don't have self-executing or automatic acceleration provisions, which would mean that if the borrower defaults, the loan is automatically accelerated and the statute of limitations is triggered at that point. In this case, we have a situation where there's no evidence in the record at the trial court that the loan was accelerated. There is no notice to the borrower with an opportunity to cure or identification that if they do not cure, the loan would be accelerated through the foreclosure process.
Well, if I got a foreclosure notice on the loan on my house, at least initially, I would think that the bank wants everything I owe them. Is that generally not the case?
That is generally not the case, because in this case, the notice of sale that Mr. Bridges relies upon doesn't contain any evidence or any indication that the loan has been accelerated. In fact, there's a statute in Arizona, ARS 33, I believe it's 518, if I have it correctly, that allows a borrower up until 5 days before the actual sale date to just simply pay the amount that's due in default on the loan, as opposed to paying the full amount that is required to pay off the loan. So our position is in this case, there's been no evidence that the statute of limitations was triggered by the notice of sale, because the notice of sale doesn't provide clear and unequivocal intent by the creditor to accelerate the loan and demand the full debt due.
If the notice had said we're accelerating the debt, how does that? What would the interplay be with the Arizona statute? Is a lender not entitled to accelerate the debt?
And my position would be, because there's no evidence of the prerequisite to that note, the paragraph 22 letter that's supposed to go to the borrower 30 days before the initiation of that process, there would be no acceleration of the debt. There may be
I'm just asking if the letter had said we are accelerating the debt because you've defaulted. What happens then with the statute? Are they entitled to just pay the amount that's owed?
That's actually a very good question. Yes. So even if there's a letter that goes out and then a following notice of sale, and there is some clear intent to the borrower or the debtor that the creditor is in fact accelerating debt, the statute still permits a borrower to pay the amount due, the missed payments plus some other fees, to reinstate the loan and take it out of foreclosure status. In this case, we don't even need necessarily to get there, because you've got two situations where we have bankruptcy tolling, which we know when we read the In re Smith case and the Milanarczyk case, that NationStar is entitled to a day-to-day tolling of the statute of limitations for each and every day that the loan was in bankruptcy. Now, in the record, we have evidence that there were 2 bankruptcies filed. Well, that may not seem like much. When you actually dig in and figure out what happened in those bankruptcies, you see that these bankruptcies lasted for years. And with the first bankruptcy that Mr. Bridges filed, he didn't comply with the court's requirements to provide documents. What the court did was it dismissed the bankruptcy. Instead of filing a new case and risking a potential for a borrower refiling, Mr. Bridges moved to reinstate his bankruptcy. The court granted that. And we saw that pattern happen 5 times in that first bankruptcy for a period of multiple years. Every time the court reinstated the bankruptcy, the automatic stay was put in place. And we know from reading the bankruptcy code, the automatic stay prevents the servicer or the lender from seeking to enforce the debt through foreclosure.
Can I ask about 11 USC section 108C? Does that have any bearing on on tolling? Doesn't that suggest that you have 30 days after a stay is lifted? Does that contemplate that tolling has? Why would that be necessary if the fact of the bankruptcy proceeding necessarily tolls everything?
Well, there's definitely, in the bankruptcy code, in the bankruptcy context, typically a servicer or anybody seeking to enforce a debt against the debtor has 30 days after the bankruptcy is dismissed to move forward. However, the pattern, if I remember correctly, the pattern of these reinstatements were such that they were done so quickly that even if the servicer mobilized perfectly, it wouldn't be able to foreclose, because it would have to potentially issue a new notice of sale. It would have to get the dismissal of the bankruptcy and then be able to move forward. It doesn't happen sort of, as many people might believe. There's no rush to foreclosure by servicers. So while you may have a 30-day period of waiting before you could proceed, in this case, because there were multiple bankruptcies and multiple reinstatements done very quickly, almost in a very schematic way, the servicer was not able to move forward foreclosure in many words quick enough.
Was there foreclosure? I'm just saying, after the second one, when the bankruptcy is over, is there some requirement that something happened within 30 days after the second bankruptcy or the continuation of the first one has been dismissed?
It's possible the servicer would have had to issue a notice under the deed of trust to be able to proceed forward, because, like I said, there's no evidence of that in the record. And when we're also looking at the bankruptcies, I'll also note for the court that under an equitable tolling theory, there were loss mitigation applications going on at the same time. So while Mr. Bridges was enjoying and actively stopping the foreclosure through the bankruptcy, he was also submitting and requesting loss mitigation help from the servicer to stay in his house while not making payments, of course, but seeking a way to be able to make payments and to keep his house. Now, those stays would have been in place because the servicer has a policy in place that they won't dual track the borrower. There are also federal statutes involved that require the servicer to review a borrower for loss mitigation. And we know that from the record, Mrs. Wallace, who was NationStar's affiant, which is really the only affidavit in the record that is admissible, identifies a number of instances where NationStar told Mr. Bridges that we've received your application, we will be putting the foreclosure on hold during the evaluation process. Not only were there multiple 5 loss mitigation applications over a period of roughly 4 years, there were also 2 requests for short sales where Mr. Bridges was asking NationStar to review the contract he received on his property and allow him to sell the property for less than the debt owed. Of course, NationStar again told Mr. Bridges that we will hold off on foreclosure while we evaluate your request. And not only did we send that in writing, we also told him on the phone, and it's been identified in Ms. Wallace's affidavit each time he was told according to his business records. So Mr. Bridges has effectively used all available options to him to delay the foreclosure while not complying on his end with any of the requirements of the bankruptcy court to provide documents. And in many instances, not providing the documentation necessary to NationStar to review him, knowing all the while he would be able to stay in the house and not pay his mortgage and live essentially mortgage-free. Now he's attempting to use those delays and his active interference with NationStar's ability to move forward with foreclosure as a shield to foreclosure now. Now, if the court provides the day-to-day tolling that's called for under the Smith case, NationStar would be well within the statute of limitations to foreclose, when also coupled with the fact that this litigation would allow NationStar to toll the statute of limitations even further.
Is equitable tolling something we would reach in the first instance on appeal?
Well, I believe the court can. It's in the record, and the review of the court could do so. There is some case law that suggests that equitable tolling, I think I know what you're talking about, is more of a fact issue for the trial court. However, it's in the record. There's been no dispute over either the bankruptcies, the time the bankruptcies were in place, the stays that were in place, or the fact that Mr. Bridges submitted these loss mitigation applications and requested help on his mortgage. There's been no dispute, no objection to the evidence that's been provided, and there is no dispute of the time frame necessarily that those days of tolling should apply. Now, Mr. Bridges has taken the position that NationStar should have foreclosed despite his client, despite Mr. Bridges submitting his loss mitigation applications. He also took the position at the trial court level in the summary judgment hearing that NationStar should have foreclosed once the court denied his request for preliminary injunction. I would submit to the court that it would be improper for NationStar in a case like this, where the borrower is challenging the ultimate right to foreclose, to move forward and quickly foreclose on the property during the pendency of the case. In hindsight being 2020, it would have been a potentially damaging result to Mr. Bridges had NationStar done that and sold the property to a third party, resulting in potential eviction from the house. So NationStar would be entitled to tolling for this litigation as well.
Counsel, what effect, if any, is the fact that you stopped the foreclosure proceedings to deal with a short sale possibility? Does that factor in at all on this issue?
I think that's probably if you look at the arguments that we've made, that's the second of the arguments, the equitable tolling argument. For us to have stopped foreclosure to review for a short sale is no different than us stopping foreclosure to review a borrower for loss mitigation, where they're going to try to retain the property as opposed to sell the property you would still be able to, you'd still be entitled to the tolling as well. A short sale is simply a way for the borrower to no longer pay on the mortgage, to be able to move forward without the issue of having a completed foreclosure on their record. It also allows them to walk away from the mortgage with less than the amount due. And so it really has no bearing whether it's a loss mitigation application for someone who's going to save their house or whether it's a short sale application. They're basically one and the same. And in fact, they're also one and the same for the most part in terms of the review that's being done by the servicer. I want to turn really quickly, because I know very little bit of time left. The fact that when you look at the record, and our firm came in right before the summary judgment hearing, and the record was fairly incomplete with evidence of acceleration. The court can look at the record and see that the only evidence that Mr. Bridges relies upon, which could be admissible, is the notice of trustee sale, which in and of itself, absent any other evidence of a notice under the deed of trust, paragraph 22, or the note, is not evidence in and of itself of acceleration. And that's the burden that Mr. Bridges had on summary judgment, in addition to opposing summary judgment, was to establish that acceleration did occur. He didn't do that. He didn't satisfy his burden. And when you take in the effect that when NationStar moved for summary judgment, it did present evidence that there was no acceleration, evidence that Mr. Bridges had for over 2 years, didn't do any discovery on the issue, didn't seek documents from the servicer at the time who issued the notice of sale. You can see that there is when NationStar shifted the burden of Mr. Bridges on its summary judgment motion, Mr. Bridges did not satisfy his burden to rebut it. And that is another basis upon which the court can deny summary judgment for Mr. Bridges and enter judgment for NationStar because there's a lack of evidence. There was a
counsel.
Yeah.
How do you address that under our Miller design case?
Andrew Miller. So in Andrew Miller, where it's just you start to distinguish it from our case. Andrew Miller, the parties agreed there was acceleration. They agreed that there was acceleration on the loan, and that the sole disagreement was on deceleration. In this case, we don't agree that there's acceleration. We disagree with Mr. Bridges and have presented evidence there was no acceleration. Therefore, we don't reach the issue of deceleration on the loan. And I also want to kind of point out something about Andrew Miller that may be informative to the court. Andrew Miller said, when you decelerate a loan, you issue a notice of cancellation of the trustee sale. It has to have very clear and unequivocal language that the loan is being decelerated and put back into the original terms. It would seem odd that a deceleration notice is required to have that information in it, while a notice of sale doesn't have to have information that clearly and unequivocally tells the borrower that the loan is being accelerated. You would think that turnaround would be fair play, that a notice of trustee sale should include that same specific language in it to establish for the borrower when they receive that notice that my loan has been accelerated. It doesn't. So I think Andrew Miller is instructive to a point, but doesn't get us to where we need it to be for the purposes of these facts. And I can tell that when this case was before the trial court, Judge Hagee was very, very concerned with the outcome. And I'm sure this court has read his summary judgment order, where he even says in his own words that the result of summary judgment for Mr. Bridges was grossly inequitable. And he's right. And it is grossly inequitable.
Counsel, can I ask, what was the argument, if any, about whether the application for modification could be considered to be an acknowledgement of the debt? Was that something that was developed at all?
That wasn't very, very developed. In fact, we wouldn't argue it. I wasn't planning on arguing it today. I think there is case law from other jurisdictions that would suggest that the acknowledgement that there is a debt, the acknowledgement that there is a loan that's going to be repaid through a modification, which is what Mr. Bridges was applying for, acknowledges the debt itself and would advance the statute of limitations and trigger it from that point forward. We don't rely on that argument. and wasn't going to do so in oral argument today. Now, I think with the limited time I have left, I think the real policy, sort of public policy result here is, and Judge Hagee said it, I think very well in his order, even though I don't agree with the outcome, was that if lenders and servicers are not permitted to have tolling to be able to say, borrowers, we're going to help you save your house, they're going to move forward quickly. And I don't think that's the intent of what we want from the case law. We want lenders and servicers to work with borrowers. We want them to keep their houses. We want their families to stay in their houses, go to the same schools. With someone who is able to use the bankruptcy court loss mitigation as a way to delay the process and actively prevent a servicer from enforcing its right, it does create the incentive for a servicer or any company who's in a very similar situation to move forward with foreclosure, to disregard a borrower's multiple attempts to say, please help me, please let me stay in my house. And that was, I think, where the court felt that the Court of Appeals could give guidance to the trial courts that they need to review and consider tolling in the bankruptcy context, which clearly here is significant in terms of the day-to-day tolling, as well as tolling from the loss mitigation context, because that is really sort of the aim of these statutes and these regulations and these policies of servicers, to be able to provide borrowers an opportunity to save their homes. I think the court could set a precedent today that equitable tolling based on loss mitigation in the servicing mortgage context applies, and that there should be tolling day to day while those applications are pending. And the court has in front of it the days in which Ms. Wallace testified that the applications were pending, as well as in the days that are in a brief, and that the bankruptcy court and the bankruptcy code, the stay that's imposed should also provide the borrower, should also provide the servicer and the creditor a day-to-day tolling, as the Ray Smith case holds in Arizona. Thank you very much.
Thank you, counsel. Counsel, now I can see you can begin your argument. Thank you.
Thank you. May it please the court. I'm Nat Nickley for Plaintiff Appellee Lavelle Bridges. Mr. Balzer and I were just talking yesterday that there's a lot of ground to cover in this case, and it's really difficult to do it justice in 20 minutes. Because of that, I'm going to limit my talk to the two big areas of disagreement in this case. I'm going to rely on my answering brief for the rest. The first area of disagreement is if the debt was accelerated by filing the notice of the trustee's sale, therefore starting the statute of limitations on the entire debt. The second area of disagreement is if the statute of limitation was told for any reason. So let's talk about acceleration. Baseline versus Madison is the authoritative rule. It says that acceleration is imputed when the creditor undertakes some affirmative act to make clear to the debtor it has accelerated its obligation.
Well, but counsel, if the particular contract at issue has a specific acceleration clause that's optional, that has to be invoked, if a foreclosure occurs, but no one says boo about the acceleration clause, how are the parties on, how are they aware that it's being accelerated if that clause hasn't been invoked?
I'm glad that you asked that, because Baseline dealt with this issue too. I believe it was an optional acceleration clause in that case, and that was one of the defenses raised by the creditor, that it hadn't exercised its option. And this is why the Baseline rule exists. It's because we don't need to divine the secret intent of the creditor. The Baseline rule creates this bright line that it held that the action of repossessing property was sufficient to exercise the option to accelerate. In other words, if there is an option to accelerate, the fact that they start acting towards repossessing the collateral, that itself shows that the debt had been accelerated.
Well, counsel, then if the very fact of foreclosure accelerates the debt, why bother with an optional acceleration clause? That clause would mean nothing if the very fact of foreclosure accelerates the debt.
Well, Your Honor, I believe they're referring to, I think it's paragraph 22 of the deed of trust. And believe it or not, I think I diagrammed a sentence in one hearing at trial court, which is that it's worded that upon option of the creditor, he may accelerate and notice the trustee's sale. So we've had the position that this was in fact not optional. But that aside, we believe that the baseline rule applies to the foreclosure because everyone knows that when a bank notices you for foreclosure, they're doing it to take the entire amount of the debt owed and not just the amount past due.
Counselor, doesn't everyone also know that there's a statute that says that you can forestall the foreclosure by paying the amount due?
Right.
Yes,
Go ahead.
it's ARS 33813.
That's correct, but that statute is not proof that acceleration hasn't occurred. What it is it's a legislative carve-out that simply allows a creditor to decelerate the debt and stop the foreclosure if he meets that statutory provision. That we have to understand that the deed of trust screen is a creature of statute. And so the legislature has made particular nuances to it on how it wants it to run. And I think the baseline standard has been used by a lot of other cases to plot a line about what acceleration means, what affirmative acts accelerate a debt. Other cases have said things like demand for full payment, repossession of collateral, the commencement of a foreclosure action. They're all things which accelerate debt.
Council 33813A says when all or a portion of a principal sum becomes due or is declared due by reason of breach or default. If the act of foreclosure accelerates the entire debt, then why does the statute say or a portion of a principal sum? I mean, that to say a portion of a principal sum presupposes that the action for debt, which would be the foreclosure, doesn't mean all the debt is due, or else you would just say when the debt becomes due, you wouldn't say when all or a portion of principal sum is due.
Well, if I understand your question, you're asking if that statute says all or a portion of the debt has become due. I believe that we've never argued that the statutes require a recovery of the full amount. They only make the allowance for it, and that the use of the optional acceleration clause has been noted in Miller Designs as it uses an analysis. It went back through the other cases that use the baseline rule.
But by the way that you're applying the law, then anytime there's a foreclosure, it's not optional. And what would a party have to do to make something truly optional?
I would say more clearly communicate what they're doing. In the hearing for the motion for summary judgment, Nation Star had admitted that the filing of the notice of trustee sale could have no other reasonable intention but to recover the full balance of the debt. And the reason why everyone takes this position is because the use of Arizona's anti-deficiency statute, that if you foreclose on for only the amount past due or a partial amount, what would happen is that the remainder of the amount would be unretrievable by the creditor, because the anti-deficiency statute precludes him from collecting on any balance beyond what was received in the bankruptcy sale. When Nationstar was pressed by Judge Heggie, he had to admit that there was no other reasonable intention of a bankruptcy foreclosure notice, and that no other action was necessary for a creditor to receive the full balance received from the foreclosure sale once they've noticed the trustee. So the fact that they've noticed the trustee means that their hands are off and the trustee knows to move forward and recover the full amount. What you would have to see is some note.
When you mention the anti-deficiency statute, isn't it more accurate than to say that the creditor is just foreclosing on the value of the property? They're not really accelerating the entire amount. They're only going to get the value of the property. There's no deficiency after if it's worth half the amount of the loan, they haven't, even in that circumstance, they haven't accelerated the full amount. If you're saying an anti-deficiency prevents them from getting anything beyond the value of the property.
Well, we don't know no one knows what the house is going to sell for at foreclosure. And that is a gamble, but this is the way the scheme was created. But
we do know that if your client had proffered the amount due and not the full accelerated amount anytime before the foreclosure, that the debt would not be accelerated. Is that accurate?
Can you say that again?
If your client had proffered the amount due and not just the entire accelerated amount, if he'd proffered that amount, the foreclosure would not have happened.
That's correct. But what I look at this statute is that the debt had been accelerated, and the statutory provision to pay the past due amount simply decelerates the debt. It resets it by the statute back to the position prior to the default.
So under the statute, then no debt can be accelerated, or if the debtor pays the amount due, then the acceleration automatically stops. So if that's the case, then there is no real acceleration.
No, I think that both case like Miller Designs talks about unilateral deceleration, and all this is a statutory provision by which the debtor can unilaterally decelerate the debt. Do you have more questions about the statute here?
Yeah, please.
So I would argue that the industry standard and the common knowledge standard, and baseline says the baseline standard that it's clear to the debtor that it has accelerated the obligation, that everyone knows how foreclosure works in Arizona, that when you're noticed for the trustee sale, they're coming to collect the entire balance of the loan when they foreclose on the house. And so
actually they're only coming to collect the value of the house, right? If it's
right. Well, they take as much as they can get. But if the house sells in excess,
that's different than saying I'm accelerating the entire amount if the house is worth less. So it's kind of hard to say that's an automatic acceleration of the entire amount.
Well, then what it's saying is that if the house sells for more than the amount, then they're due and owing that full amount up to the amount that they're owed. So it's a way of looking at the ambiguity of the situation. An ambiguous future amount that's unknown and making a claim. How much can I take? Up to the amount that I'm owed, whatever that house sells for. I'd say that it'd be difficult to create a statute which articulates it any better than that's articulated. So
could you address why equitable tolling shouldn't be applied in light of In re Smith?
Yeah, absolutely. So in In re Smith, flip into my notes here. First of all, I'd like to point out that equitable tolling is a new argument that was not argued at trial, and that it's a different claim with different elements than what was brought to the trial court. But since the court has asked, equitable tolling requires a party to show two things. One, that it diligently pursued its claim, and but for the extraordinary circumstances, it was prevented from timely filing. The application of this, I'm going to apply it to the bankruptcy statute, unless the court wants me to apply it to the other actions. Congress wrote 1(8)(c) to dictate how a bankruptcy stay affects the statute of limitations for non-bankruptcy claims. It says that a bankruptcy does not by itself toll the statute of limitations for these claims. It only allows for tolling when there's a non-bankruptcy federal or state law which tolls the bankruptcy stay, or the statute of limitations runs during the stay. The court, NationStar has relied on In re Smith because there's an absence of Arizona statute or Arizona law here. Now, it's important to note that Arizona doesn't have a law because other states do. Other states have a day-for-day tolling. California and Oregon.
What do you make of the pronouncement? Isn't In re Smith in response to a question from the district court as to what Arizona law is?
Yes, yeah. In re Smith, it's a case that is a case about how a bankruptcy stay affects post-judgment enforcement. It does not consider pre-judgment actions like in our case. Specifically, it's about a judgment creditor's ability to file a renewal of judgment under 12-1551, which is post-judgment enforcement. The Smith court ruled that the state did not extend the time to file the renewal, but in its dicta, the court noted that a judgment creditor's ability to enforce a judgment under 1551 was suspended by that stay. However, it made no speculation about how it would apply or if it would apply to a pre-judgment action. So we have 108 doesn't suspend the statute of limitation by itself. There's no Arizona exception, and Smith doesn't apply because it only talks about post-judgment enforcement, specifically 1551, which is the filing a notice of renewal of judgment.
So in your view, then the lender needs to, if a stay is lifted, there's nothing that keeps the lender from going forward with the foreclosure. Right.
And in equitable tolling, I think that NationStar tries to shoehorn equitable tolling in 108C by claiming that the bankruptcy itself, the bankruptcy stay itself, is an extraordinary circumstance for which equity would demand tolling. I don't think that was the intent of Congress. For example, there's case law that supports this. Wombles v. Hogan says the court ruled that a bankruptcy stay was not an extraordinary event. It did not warrant equitable tolling and held that the plaintiffs failed to exercise due diligence by not timely pursuing their claims when the bankruptcy stay was lifted. Now that goes to the first element, that there has to be an extraordinary circumstance, but NationStar also fails on the second element because it didn't pursue its rights diligently. Diligent pursuits of rights in Arizona is a high standard to meet in Arizona. In McLeod v. State of Arizona, an attorney was 2 months late in filing a claim because his brother's caretaker died. His wife had heart surgery. He had 2 knee surgeries and was heavily medicated. His mother died. he had gallbladder surgery and his backup attorney contracted tuberculosis. Even with all this, the court held that equitable tolling did not apply because counsel did not show he was so disabled during the entirety of the time that he could not have taken steps to ensure the claim. Because there was times where he could have acted, but failed to, he didn't meet the standard of diligence required for equitable tolling.
Is it different where the other side does things that that lead the lender to hold off? I take it that wasn't an issue in the case you're citing.
No, not in that case, but
if you're asking for loan modifications,
right.
And just out of curiosity, so your view of whether a loan modification is an acknowledgement of the debt?
No, there's substantive case law that says, or at least there's several Arizona cases that clearly state that a loan modification or request for short sale or refi are not in fact acknowledgements of the debt, because in Arizona there's specific standards required to do it, including it being in writing after the statute of limitations failed. And in fact, the courts have identified these loan mods as request for negotiations, and not in fact an offer as it would be in the contract, which doesn't meet the standard of acknowledgement. With the little time I have left, I'd like to just point out that it doesn't matter if NationStar's tolling arguments apply, because ARS 33816 identifies that the filing of a judicial foreclosure sale or the completion of a trustee sale are the two things that stop this particular statute's statute of limitation clock. NationStar didn't do any of those things. When Mr. Bridges was not granted a preliminary injunction, NationStar could have completed its non-judicial sale and chose not to. Therefore, NationStar slept on its rights, and the statute of limitations continued to run after the denial of the preliminary injunction. And it kept running until the trial court granted the permanent injunction in December 2018, which is well beyond any of the tolling periods that could be reasonably applied to this case. Thank you, Your Honor.
Thank you, counsel. We appreciate your argument today, and we'll take this matter under advisement and issue a decision in due course. We stand adjourned. Thank you.
Thank you very much.
Thank you.